Hey everybody, welcome back to the Shanty. You know, it's funny, we go like a month with nothing to talk about, and then boom, boom. This week we're going to talk about COVID. Why are we talking about COVID again? COVID's done. The World Health Organization has said the global pandemic is over and it's now an endemic. The federal government's pandemic emergency has been lifted. What are we talking about COVID for? Well, think way back to the beginning of COVID when all this started. The EEOC released a thing called What You Should Know About COVID-19 and the ADA, the Rehabilitation Act, and other EEO laws. And it was a question and answer that was very helpful throughout the course of the COVID pandemic. Now, during the course of the pandemic, this thing's been updated like 20 times, and it's up to about 116 questions. Well, on May 15th, the EEOC issued another update to this guidance that we want to talk about here real briefly. Now, this is the last update. At least that's the plan. How do we know it's the last update? Because the chair of the EEOC basically said it was the last update. In the press release on this thing, she said, quote, "This installment is the capstone to our comprehensive resource of question and answers on COVID-19 and the anti-discrimination laws enforced by the EEOC," end quote. And then she went on to say, quote, "The end of the public health emergency is an important milestone, and this will help employees and employers understand how the Americans with Disabilities Act, the Rehabilitation Act, and other federal laws continue to protect our nation's workforce from employment discrimination. The EEOC remains committed to vigorous enforcement of these laws." So again, we've got this guidance. It's out there. We've used it over and over and over and over and over again during COVID. We're at the end of COVID now. Where does the guidance come in and how does it help? Well, the EEOC pointed out three main areas that they wanted to emphasize in their changes. Now, like I said, there's about 116 questions in this thing, and about 30 of them were updated in this particular update. So that's not a ton, but it's significant. So again, in the press release, the EEOC emphasized what they called three key updates, and they include the following. First of all, the first thing they wanted to point out to everybody and make clear was that the end of the public health emergency doesn't mean that employers can automatically undo all the reasonable accommodations that they made to people during the pandemic. And the Q&A is D20 if you want to go look at it. And they say, the question is this: as a result of the end of the COVID-19 public health emergency on May 11, 2023, may employers automatically terminate reasonable accommodations that were provided due to pandemic-related circumstances? In other words, all that stuff we did because of the pandemic, can we undo it? All those reasonable accommodations that we did because of the pandemic, can we undo it? If the pandemic's over, we shouldn't have to make those reasonable accommodations anymore. The EEOC says, no, you cannot do that. This emergency declaration dealt with issues involving health care coverage and access to treatment. It did not address the ADA and Rehabilitation Act requirements regarding provision of reasonable accommodation. Therefore, the end of this public health emergency declaration does not automatically provide grounds to terminate reasonable accommodations that continue to be needed to address ongoing pandemic-related circumstances. And then they give examples: continued high risk to individuals with certain disabilities if they contract COVID-19, for example. Then the question and answer goes on to say, however, an employer may evaluate accommodations granted during the public health emergency and in consultation with the employee assess whether there continues to be a need for reasonable accommodations based on individualized circumstances, which is consistent with what the whole ADA says all the time about accommodating disabilities. Consistent with the ADA's business necessity standard, this evaluation may include a request for documentation to address why there may be an ongoing need for accommodation and whether alternative accommodations might meet those needs. In other words, what the EEOC is saying to you here is, if you have an employee that's being accommodated as a result of the pandemic, you don't get to automatically take away that accommodation. You get to engage in the interactive process to determine if that accommodation is still necessary as a result of the public health emergency being over, the pandemic now becoming an endemic, us sliding out of the COVID thing. So don't automatically take away those accommodations. Engage in the interactive process, which, as we all know, is the key to ADA compliance anyway. The other revisions of the guidance, the second big area of revisions in the guidance involve long COVID and whether long COVID can be a disability under the Act, and whether COVID can be a disability under the Act. And we all know that COVID can be a disability under the Act, but it isn't automatically a disability under the Act. The same thing with long COVID. It can be a disability under the Act, but it isn't automatically a disability under the Act. So if we go to new question N2, the question is, when is COVID-19 or long COVID an actual disability under the ADA? And what by actual, what they mean is not regarded as or not having a history of, but an actual disability under the ADA. And really what the EEOC does here is they just apply the normal ADA rules that we all know so well. And here's what they say: applying the ADA rules, and depending on the specific facts involved in an individual employee's condition, a person with COVID-19 or long COVID has an actual disability if the person's medical condition or any of its symptoms is a, quote, physical or mental impairment that substantially limits one or more major life activities, end quote. That's the definition of disability under the Americans with Disabilities Act. No big surprise there. The EEOC goes on to say an individualized assessment is necessary to determine whether the effects of a person's COVID or long COVID substantially limit a major life activity. This will always be a case-by-case determination that applies existing legal standards to the facts of a particular individual circumstances. And then they go on to say a person infected with the virus causing COVID who is asymptomatic, or a person whose COVID-19 results in mild symptoms similar to the common cold or flu that resolve in a matter of weeks with no other consequences, will not have an actual disability within the meaning of the ADA. However, depending on the specific facts involved in a particular employee's medical condition, an individual with COVID might have an actual disability if they do have symptoms that substantially limit a major life activity. No big surprise there either. All right, and then in staying with, in other words, nothing's really changed there under the law. We have to continue to apply the ADA as it's written to COVID and to long COVID to determine whether it is a physical or mental impairment that substantially limits a major life activity. And that's how we know whether or not COVID or long COVID in a specific circumstance is a disability under the Act. And like everything else under the ADA, it's an individualized assessment. With rare exceptions for things like cancer and AIDS and so on. It's an individualized assessment. Now, the other thing that the EEOC does in this guidance is they talk about accommodating long COVID. How do you accommodate long COVID? And the EEOC actually gives an example here of things you can do to accommodate long COVID. Now, it's not an all-inclusive list, but it's an example of what employers can do to accommodate an employee that has long COVID and has these ongoing symptoms that remain for a long time after the disease has cleared. And it's question D19, what are examples of reasonable accommodations that may assist employees with long COVID? And here's what the EEOC says about that. Quote, the possible types of reasonable accommodations to address various symptoms of long COVID vary depending on a number of factors, including the nature of the symptoms, the job duties, and the design of the workplace. No big surprise there, right? Accommodations are always going to vary depending on those things. But the EEOC then goes on to list some examples. Some common reasonable accommodations may include a quiet workspace, use of noise canceling or white noise devices, and uninterrupted work time to address things like brain fog, alternate lighting and reducing glare to address headaches, rest breaks to address joint pain or shortness of breath, a flexible schedule or teleworking to address fatigue, and the removal of marginal functions that involve physical exertion to address shortness of breath. Okay, so that now we at least have some examples of what the EEOC would think is a reasonable accommodation when it comes to something like long COVID. Now, the last thing the EEOC points out in the press release as an area of emphasis, what they call a key update, is, interestingly enough, the issue of harassment of applicants and employees with disability-related issues related to COVID. And here's what the press release says. For employers, the updates include tips about remaining alert for COVID-related harassment of applicants or employees with a disability related to the need to continue wearing a face mask or take other COVID precautions at work. In other words, what the EEOC is saying in this press release is they are concerned that people who choose to continue to wear masks might get grief from their coworkers, and that's a no-no. You can't do that. So what's the question? The question E2, that the EEOC gives in the guidance is, are there steps an employer should take to address possible harassment and discrimination against employees in connection with the pandemic? And the EEOC says, of course, yes. Otherwise, they wouldn't have asked the question. An employer may remind all employees that it is against federal EEO laws to harass or otherwise discriminate against coworkers based on race, national origin, color, sex, including sexual orientation, gender identity, and pregnancy, religion, age, 40 or over, disability, or genetic information. No big surprise there. That's the law, right? It's illegal to discriminate on those bases. But then they go on to say this. It may be particularly helpful for employers to advise supervisors and managers of their roles in watching for, stopping, and reporting any harassment or other discrimination. An employer may want to provide illustrations of pandemic-related harassment for supervisors, managers, and all other employees to help them understand what actions may violate the EEO laws. For example, one illustration might show a supervisor or coworker violating the act by harassing an employee with a disability-related need to wear a mask or take other COVID precautions. Another illustration might show a supervisor or coworker violating Title VII by harassing an employee who's receiving a religious accommodation to forego mandatory vaccinations. Finally, an employer may also make clear that it will immediately review any allegations of harassment or discrimination and take appropriate action. Now, is it me? Or is this just the EEOC saying you need to update your harassment training and give it to all your managers and supervisors? Because that's what it sounds like to me. It sounds like that's what the EEOC is saying. Now, look, hopefully this is the end. Hopefully we never, ever, ever have to do a COVID podcast again. I'm sick of it. You're sick of it. Nobody wants to hear about it. Nobody wants to talk about it. But it's still out there. We can't ignore it. And the EEOC has made that clear with this most recent update. So you should go take a look at it. I'll put a link. I'll try to put a link in this shanty that'll get you there. You won't be able to click on it, but at least you can know where you're going. Otherwise, go to your Google machine and type in COVID-19 and the ADA, and that should get you to the guidance. If you have any questions, give us a call. We'll see you next time.